And the case of Una Energy is referred to in my friend's skeleton. It's at tab 13 of the Joint Authorities bundle.
Slight thought, that my authority next trial. That is because all the authority was received on January 28.
Dawn, I think there's a duplicate copy of this back in our room. I've got it going as far as 17. So that's what we
Keep going.
It's at paragraph 30 of my friend's skeleton. In that paragraph, my lords, my friend says that the duties of the Minister of Finance are comparable to the role of the court in giving effect to mutual legal assistance agreements. And then in paragraph 30, reference is made to the Una Energy case. And in particular, the quote from the case that you see at on page 15 is highlighted. The object of the international scheme is that as between friendly states with whom there are treaty obligations of mutual cooperation, requests for MLA will be acted upon, and as quickly as possible, at least until there are compelling reasons for not doing so. The significant difference, my lord, and the basic facts in Una Energy. The basic facts in Una Energy were these. The Serious Fraud Office in the UK was seeking assistance in connection with a criminal investigation of bribery and wished to the criminal authorities in Monaco to obtain information to assist in the investigation. And what happened was the Serious Fraud Office issued what was called a letter of request under the Crime International Cooperation Agreement, or whatever it is, Act of 2003. The UK statute, similar to an act we have here, which enables criminal authorities in separate jurisdictions to request assistance and evidence, obtaining of evidence. The important distinction, however, is this, that in the Una Energy case, there was no intervention of a court in the issuance of the letter of request. It is one state authority communicating directly with another state authority in a different jurisdiction. My friend, I believe, has misconstrued the case and assumed that a court was involved in the issuance of the letter of request. And that becomes clear in paragraph 31 of the skeleton. You'll see in paragraph 31, my friend says this: Lord Justice Gross, on behalf of the administrative court, this is considering the Una Energy case, considered the UK's international obligations in respect of outgoing and incoming requests for mutual legal assistance under various treaties. At issue was the sufficiency of the disclosure on behalf of the Serious Fraud Office in making an application for a letter of request. My Lord, the point I'm trying to illustrate is that there was no application. I'm assuming that what my friend means by that is an application to a court for the issuance of a letter of request.
But you say it was just one authority to another.
Yes, and that becomes clear in paragraph 6 of the judgment at tab 13. At paragraph 6 of the judgment, giving the background to the case, Lord Justice Gross said, on the next day, the 23rd March 2016, the SFO sent the authorities in Monaco, the Monegasque authorities, a letter of request seeking the assistance of those authorities in relation to the SFO's criminal investigation. There was no intervention or interposition of a court between the two authorities. And my friend says, well, there you go. There's no a duty of candor in that case, because that was the challenge. In this case, the challenge to the issuance of the letter of request was that those who were being investigated or parties associated with them said to on a judicial review application to quash the letter of request, were saying you ought to have made full and frank disclosure to the Monegasque authorities of material facts. And the judge in this case said, no, there was no duty, even between the two state authorities. In fact, in the decision, the judge contrasted that with another set of circumstances where, for example, a police authority is seeking a search warrant, a domestic search warrant. At paragraph 32, I would ask my lords to turn to paragraph 32 of the judgment in the unit energy case. This is the right analogy or comparison. At paragraph 32, the judge says, first, the nature of the disclosure obligation when a law enforcement agency seeks a domestic search warrant on an ex parte application is such as to render it peculiarly inappropriate to a LOR, to a foreign authority. An authoritative statement of the relevant duty of candor appears from the judgment of Lord Justice Hughes, as he then was, in Re Stanford International Bank Limited. And he quotes from that decision where it said, it is essential that the duty of candor laid upon any applicant for an order without notice is fully understood and complied with. It is not limited to an obligation not to misrepresent. It consists in a duty to consider what any other interested person would, if present, wish to adduce by way of fact or to say in answer to the application, and to place the material before the judge. In effect, the prosecutor seeking an ex parte order must put on his defense hat and ask himself, what if he were representing the defendant or a third party with a relevant interest, he would be saying to the judge. And having answered that question, that is what he must tell the judge. That is the appropriate comparison to be made in this case. And it is the same duty of candor which we say exists almost in every way. It is the same. And it's a duty to make full and frank disclosure, to make a fair presentation of the case, which includes putting to the judge what the other side would say if they were present.
So if I understand this correctly, Mr. Kesram, what Stanford says is that where one authority makes the request of another authority, the duty of candor is the same as it would be in making an application to a court.
No, I think what this case, Unit Energies, is authority for is that
Why then does Stanford indicate that the duty to consider what any other interested person would, if present, wish to adduce by way of fact, or to say an answer to the application, and to place that material before the judge?
that is in applying for the issuance of a search warrant. Yes. So if in a purely domestic case, a police.
Well, that's why I said, is that the same as one authority making an application to the other
No.
authority?
No, because you don't get the search warrant from another authority. From a court.
I'm sorry, I missed the top where we're talking about a law enforcement agency seeks a domestic search warrant on an ex parte application. I have it.
Yeah. So between states, the duty of candor in requesting information be provided. Between state authorities, no duty of candor. When it may be the case that in the requested authority, under the criminal request, goes to the court for the issuance of the search warrant, he would have a duty of candor.
I think the Lord Justice Cross said, in paragraph 32, the likely colloquial response from the requested state would be an invitation to the UK judicial or designated prosecuting authority making the request to resolve its own doubts or difficulties and to reissue the LOR before when it has done so.
Exactly.
The court response to that would be, our difficulties are in fact tell us anything. But never mind, let's consider that. Right.
So the next point, my lord, is with respect to the role of the Supreme Court. And I think we've already touched upon this and more or less I've made all the submissions I wish to make on it. I just want to draw attention to the counter argument that's being raised. And that is, on behalf of the Minister of Finance, it's being said that the role of the court is part of the administrative process of issuing, complying with requests. Or enforcing agreements for provision of information. And we say that that is entirely wrong. We say that the duty of the court is, as stated in section 5.2, is to ensure that the request complies with the agreement, the TIA. And the reason that the court is concerned about that is that production orders are an intrusion into the private affairs of people who are required to produce information under this statute. And that's why, and we accept fully that there's no judicial authority, no Bermuda court decision, which actually expounds upon the role of the court. But we say the interposition of the court in 2013 between the Minister of Finance and those who may be at the opposite end of a production order was intended to make sure that there was no excessive use of the power to compel persons to divulge confidential information. And we say that, yes, that the protection of the individual who may have been served with the production order has been whittled away somewhat through various amendments of the legislation over time. First, the right to see the documents that were placed before the ex parte judge was taken away by legislative amendment. Now you have to first establish that
just a moment,
there is
if I might.
reason to believe.
Mr. Kissaran, you refer to the right.
Beg your pardon.
Now we have to establish the
Yeah.
right of review.
Yes.
And if and not unless you've established the right of review, you need more than production of documents.
Yes.
The
Mr.
documents are in front of the minister.
Justice Appeal Smelly wishes to say something.
No, it's fine. Yeah.
Yes, that right of disclosure of the relevant documents, I take it you mean the common law right that the courts had found to exist.
Yes,
Thank you.
it was a common law right, and it was recognized in not only decisions at first instance, but I think on appeals to this court in Bermuda. That common law right was recognized, and then it was taken away by amending legislation.
Yes.
So the point I'm simply making is that although those rights have been whittled away somewhat, the duties of candor that the Minister of Finance owes to the court on making an ex parte application remains in full force. It has not been taken away.
Well, you say, as I understand it, that you even have a system whereby the judge has to make the decision and the application under the statute may be made to him ex parte, and under the rules shall be made ex parte. The rules that normally apply to an ex parte application apply to this one.
Yes. There was an issue about what does the law require in terms of inter partes or ex parte application, which my lord has identified. The rules say one thing, the statute says may.
Well, that's not the problem, is it? The statute says it can be ex parte, the rules say it shall be ex parte.
Yes,
So it's allowed to be ex parte, and the rules say that it shall be.
yes. And if it is, our point is, as my lord has identified, if it is made ex parte, the common law obligations of an ex parte applicant apply in full force.
Yeah. Right.
The last point, my lord, that I wish to address you on is the test of relevance, because
Yes.
it appears that this is another point on which the parties differ. And I don't think I need say much more than this, that although the test of relevance in a TIA case is wider, it's the test of foreseeable relevance, there is nevertheless an obligation for the court to be satisfied that the documents and information being requested are relevant to the tax purpose being sought to be fulfilled by the request in the requesting state. So the court has to be satisfied, albeit that the test is a rather loose one. There still must be some connection, nevertheless. The court must be satisfied and has to address its mind to the question whether the information requested is broadly relevant to the tax purpose of the requesting state.
And in one sense, the extended definition of relevance allows something of a fishing expedition, because in the ordinary test of relevance, which shows documents you're seeking are relevant. In the extended test, in effect, you're saying, well, until we see them, we can't tell whether they're relevant, but there's a real possibility that they are. But if you say that there's a logically hard question as to what it is that they might be relevant to,
Yes.
and what one could do in the case of this kind, if it wasn't at all clear what their relevance was supposed to be, is to say, what are the sort of documents that you hope that you might find, and what would they be relevant to? And since what we know they're looking for is documents which show whether or not Reliance had a business presence in India. And that is relevant to the question as to whether or not Reliance is liable to the income, the tax on the income which has received from an Indian company. But if they're said to be relevant to something else, it's not apparent what it is that they're relevant to.
That's in a nutshell, lawyers. We deal with the question of the test of foreseeable relevance in our submissions at paragraphs 36 and 37. And we quote from Singaporean cases where the same question has been considered, and which cases have also found their way into Bermuda jurisprudence on previous cases in Bermuda dealing with that question. At paragraph 36, there's reference to the case of controller of income tax versus AZP, where it was said, and I quote, the first requirement of foreseeable relevance requires the controller on behalf of the requesting state to show some clear and specific evidence that there is a connection between the information requested and the enforcement of the requesting state's tax laws. Clear and specific evidence is necessary to prevent unwarranted disclosure of information that could not otherwise be sought from any party, including the requesting state. And in the next case, controller of income tax versus BJY, it was said, since the requested information need only be foreseeably relevant, the requesting state need not show that the requested information is demonstrably relevant for carrying out the provisions of the DTA or to the administration or enforcement of its tax laws. However, and these are the laws line, however, it must at the very least explain why the particular information requested is thought to be possibly relevant. In answer to the particular point that the minister makes, it is for the Bermuda court to be satisfied, and he would not be satisfied simply by being told that the minister has considered the question and has satisfied himself that the documents or information is relevant, which appears to be the minister's position or in this appeal, that once the minister has said that he considers it's relevant, then the court is bound to accept that view.
And of course, in the present case, all that the minister has said, the information referred to the tax purpose contained in the request,
which contains an expiration date.
And then the information sought in the request is plainly relevant to the tax purpose specified in the request.
It has to be, the information requested has to be foreseeably relevant to the tax purpose of the request.
The information that is actually stated is foreseeably relevant to the tax request that is stated in the request.
We didn't concede that.
No, I know you don't, but it's right.
I hadn't considered that question. In fact, I think we took the position when on the first go at getting a request, a production order on the basis of this request in 2019, we took the view that this was a fishing expedition.
Yeah.
My Lord, those are the main points that I wish to deal with. And I would simply like to, there's one final thing in my friend's closing paragraph. He asks this court to, I'll actually tell you what he says. suggests that this court, by its ruling, aligned the process of the application for a production order in Bermuda with the process in respect of applications made ex parte pursuant to the mutual legal assistance obligations. And I think what he's referring to is the Una Energy case, where he puts forward the proposition that there is no duty of candor in these types of cases, mutual legal assistance cases. We say that the Una Energy case isn't support for the proposition, but there's no duty of candor. And I think to take it away would probably require legislative intervention. My Lord, those are all the submissions I wish to make at this stage.
Yes, well, I have no questions. Thank you.
No further questions at this stage. Thank you.
Justice Smelly may have.
Mr. Justice Smith. Did you have a question?
I no further questions at this stage. Thank you.
Thank you. Yeah, do you want to address?
No, I'm fine with it.
The Lord will have heard from Mr. Kessler and central in all of this, and certainly in my Lord's responses. Central in all of this is indeed the role of the court, and what is the purpose in all of this. And my friend seeks to submit that somehow the minister proposed that.
Justice Smelly has a query. I'm not sure whether you're muted.
Yes, Mr. Wilkinson's mic is muted on the Zoom screen. I can hear you, but not very clearly.
I'm sorry, I thought the name was wrong. Is that better, Justice Smelly?
It is indeed. Thank you.
Thank you so much. Yes, I was saying, my lords, about the central role of the court, and clearly that's key. And certainly we would be submitting it is key, because at various points in time, my friend has referred to this review as being a review of the minister's decision. In his submissions, that is found at, I believe it's paragraph 38E of my friend's submissions.
Which paragraph, Mr. Bell?
Paragraph 38 of my friend's submissions, 38, page 15.
Right.
The role of the court in this case was to review the Minister of Finance's decision that the request complied with the requirements of the relevant TIA. We would submit, my lord, that is a complete misunderstanding of both the role of the court and the role of the minister. And it's the simple answer to the duty and the role of each, we would submit, is found in the statute, which is at tab 1 of the authorities binder. And we see at section 3.2, the minister may provide assistance to any requesting party according to the terms of the agreement with that party. Now, effectively, his role in this is to provide assistance, and we've already had a review of the TIA, which is the relevant agreement, which my friend took you through at tab 2. And the recital there, as my friend read, is that the competent authority, which in this case is the minister, Article 1, shall provide assistance through exchange of information that is relevant to the administration and enforcement of the domestic laws of the contracting parties concerning taxes covered by this agreement. Such information shall include information that is relevant to the determination, assessment, and collection of taxes, etc. Now, having received a request, he provides assistance by an application under section 5.2. So there's no review by the court as to whether the minister has done it right or has made the right decision. He's making an application. And now the court's engaged. And the court's engagement is on these terms. This is page 7 of the statute, section 5.2. The Supreme Court may, discretionary, if on such an application, it is satisfied that conditions of the applicable agreement relating to a request are fulfilled, period. Because the rest, as we know, isn't relevant for the purpose of our application and this appeal. So it is only for the Supreme Court to be satisfied that the conditions of the applicable agreement relating to a request are fulfilled. So what are the conditions of the applicable agreement? For that, we must go back to the TIA, because that is the relevant agreement, the TIA between Bermuda and India. And as we see, this was entered into in
Sorry, the tier again is where?
tab 2, my lord.
Yep.
And there's 2 copies, I think, that my lords may have. One is the more densely one, and there should be a second. Oh, it's not in that bundle. There is another format, but that, my lord, I'll just reference now. Article 5, as this deals with the exchange of information upon request. And Article 5.6. So these are the conditions of the applicable agreement that need to be fulfilled. The competent authority of the requesting party, so India, shall provide the following information to the competent authority of the requested party, Bermuda, when making a request for information under the agreement to demonstrate the relevance. Now, this word relevance is more akin to the word coherence, we would submit, because we're not dealing with foreseeably relevant, we're talking about coherence of the information to the request. So,
where
I'm at Article 5.6.
Yes, the competent one is provide the following information.
To the other competent authority.
Demonstrate the relevance to the information. I don't understand why relevance should, I can understand an extended definition of relevance, but that doesn't mean the term coherence.
The intent, my lord, in this submission is to try and show that the court, when the application is before it, to be satisfied that the conditions of the applicable agreement, that the conditions of the TIA relating to the request are fulfilled, must be able to look at the request and see that there is relevance, connection with the information being sought to the request. Coherence may not have been the best of words to use, my lord. I apologize. And as my friend, Mr. Kesseram, went through earlier this morning, we have A to H. And if I can burden my lords with going to tab
What? Which? Eight.
A to H.
Eight, wait. Oh, I see, yes.
Sorry,
I think
H,
there's eight, eight.
H.
Yes, eight.
That's a very Irish way, I'm afraid. I've never learned the other way.
Well, it's okay. It's comfortable. Okay.
I'm grateful, my lord. So if my lords have that, and then with the record of appeal, we look at the actual request form, we see A is box 7, and that request form is at page 81 of the record of appeal. The identity of the person under examination or investigation. So page 81 of the record of appeal, one sees number 7 correlates to A. B is box 9. The time
B is
period.
what?
Apologize, Lord.
I didn't hear you.
Box 9. B, the period for which the information is required, is box 9.
Right, financial year 2015-16.
Yes.
Right.
And so on, my lords. C, information requested, box 13, which probably ties in with box 12 as well. The tax purpose for which the information is requested in D is box 11, possibly 12 as well. Grounds for believing the information requested is present in the requested party. There is in possession or control. Box 14. And that's on page 84. And possibly box 15 as well. And that goes for F, box 15, 14, that information is there. And then G, a statement that the request is in conformity with the laws and administrative practices. That's contained in box 18. H, a statement that the requesting party has pursued all means available in its own territory, etc. That's also in box 18, but it's also, as we will have read earlier, in the letter that covers the request. Now, my friend has said if there's any doubts about any issues that the judge has, he can ask the minister to go off and ask India and get clarity. And would that information come back in the form of the request? No, it would be information. And the reason I reference it like that, my lords, is the covering letter is part and parcel of the request at page 80, the letter we've been looking at earlier. It's a very extreme position to take, to say that this covering letter does not form part of the request that has been passed to the competent authority. And what the judge, not to lose sight of what this submission is about, which is the role of the court, is section 5.2 in tab 1, page 7 of the Act. Is when the court has before it a summons, an affidavit, and exhibits, And the court is, on such an application, satisfied that the conditions of the applicable agreement relating to a request are fulfilled, then it is up to the court, be it the Chief Justice, or in this case, Mr. Justice Mussington on the review, to consider whether or not a production order has valid, it should validly, or in the case of Mr. Justice Mussington, has validly issued. Were the conditions of the applicable agreement relating to a request fulfilled? And, my lords, the suggestion that the letter is not part of the request is simply, we would submit, not tenable in the circumstances of the application. And the application commences at page 71 of the Record of Appeal and goes for some 35 odd pages. This is tab 7, page 71.
Sorry. I don't have the tabs on the front, so just page 71, which is the document, Minister of Finance and Reliance Globalcom.
Yes, it's a letter to the court enclosing the summons.
Right.
Nothing to dwell on. Then we have the minister of the minister, Again, nothing particular to dwell on because there's no requirement for this minute in the context of the application. There's the ex parte summons. And then we get to the affidavit of Ms. Mahogany Bean, sworn on the 26th of February, 2020. And when my lords asked earlier what documents were before the court, these were the documents that were put before the Chief Justice for him to decide whether or not to issue a production order. She recites who she is, and she recites in paragraph 2 that the previous post holder had not processed the request. The file was found in a place where it went unnoticed until recently. For this reason, the application is now being made. She refers to a paginated bundle of documents, and those are the documents my lords will have that I say go up to the very last one of them is around 122. And she says there is a minute of the minister. The court production file has the original.
Which page are you on now?
Page 78, my lord.
Right.
At paragraph 5 now, as recited in the minister, when he received the request, she recites about the TIA and that there are copies in the court. At paragraph 6, she says the request identifies Reliance, identifies the period, and all those things that we just looked at in the context of the TIA's requirements under Article 5(6). She refers to the redacted request from the Government of India, dated 10th of December 2018. And as we know, that includes the cover letter because that is part and parcel of the exhibit. She refers at paragraph 7, and this, my lord, I think there was certainly hope of what might be some lightening of the load on ex parte applications in terms of the duty of disclosure, full and frank. The respondent fully accepts that the duties of disclosure were in place at the time this application was made, and the respondent's position is and always has been that those duties were fulfilled.
Well, Mahogany Bean does not refer to the expiration of the limitation period, does she?
No, she doesn't, my lord, but
Well,
equally.
Is that material?
Well, my lord, is it material to this extent? And I would reframe my lord's question. She may not have mentioned it, but my lord, we're talking about a letter that is the very front of the request, and where it clearly says about the limitation period. I won't dwell on reading it to the court.
Well,
It's been through. But the mayor,
Not to put too fine a point on it, it's a partially illegible document in which, yes, the statement is made that the limitation period has expired, but would one not have thought that that was a matter that should be covered in Ms. Bean's affidavit?
with hindsight, of course, my lord, the answer has to be yes. But equally, I would say this to my lord, two things. One, the copy we have is not necessarily the copy that was before the Chief Justice.
Well,
And
why
it's-
is that?
Because nobody asked for the court file, my lord.
Well, why not?
Well, the respondent,
If anything turns on it, to be told we don't have the copy that the court had is, if I may respectfully say so, very unhelpful.
well,
And I'm not sure it's right, Mr. Elkinson, because what we have is Mahogany Bean's affidavit at 77, and the document, which is at page 80, is clearly the exhibit to that affidavit,
Absolutely.
marked MRB1.
no, my lord, I made myself clear. What I meant was the photocopy and what's happened since the matter was brought before the chief. There's no question this is the same letter. I'm referring to the bad copy. And
Well, none
I,
of the other documents, granted, the actual request is perhaps not as clear as it might be, but it's in nothing like the poor state of legibility that MRB1 at page 80 is.
well, 130, my lord, is another copy of it, which is much cleaner.
130 was not before. I can't see any evidence to suggest that 130 was before the judge.
Well, in fact, my lord, it's more likely that 130 was before the judge.
Why?
Than-
Because
than
it was
the
not
other one.
marked as an exhibit, and the affidavit was before the judge. What's at page 80 is clearly MRB1. What's at page 130 is not clearly MRB1.
Well, my lord, all I can say is that at no stage was there complaint made by the Chief Justice, Mr. Mussenden, about the illegibility of the document. And I appreciate the difficulty my lords find themselves in. But the reality is that this was never an issue of legibility before. And I fully appreciate, my lords, that the copying that you've had, remembering that this again is copies of copies, is not satisfactory. But the fact remains, my lord Bell, that
That's the question here.
this was before the Chief Justice. My friend refers to the fact that there is a tranche of documents, of massive volume. It's not a large volume. The Chief Justice is not under pressure of time. This isn't a commercial application where there's an urgency expressed. The Chief Justice chose to deal with this at a time and a place of his choosing. He did it on the
The
papers.
Chief Justice, with all respect, Mr. Elkinson, is going to read the affidavit of Mahogany Bean and will expect that all material matters will be set out in that affidavit.
Well,
Mr. Kesseram says, and I can follow it, that the information in relation to the limitation period, it appears in the second sentence of paragraph 2 on page 80, but no one would think from that that it had materiality, and it clearly does.
well, if I may respectfully disagree with my lord about materiality, the whole tone of this letter is all about the request.
Well, if it was material, one might expect Ms. Bean to say it is of course material, the limitation period is expired, but that is not a problem because.
That is certainly a view, my lord, that I fully comprehend. I would say to my lord that that may be the position before the Chief Justice, who's still in the circumstances, and I still would posit that he did read the letter, because not only does not Miss Bean not put out to follow my Lord Bell's reference about full disclosure, when it comes to the previous applications, which is paragraph 7, in relation to this request, there have been previous applications, production orders in respect to these taxpayers.
Paragraph 7.
Sorry, the affidavit, my lord. Page 78. Still in the same area of Miss Bean's affidavit. So she refers to the history of the defects.
Right.
And she refers specifically to the affidavit of Mr. Riley. Now, she doesn't regurgitate Mr. Riley's affidavit. She asks the court to read it. Now, my friend says that's too burdensome. Mr. Riley's affidavit is some 3 pages long.
Well, what would that tell us about limitation?
Nothing to do with limitation at this stage. This is all about the other allegations of non-disclosure.
Oh, I see.
But my lord has to recall that in the judgment of Mr. Justice Mussenden, he was confronted by a plethora of allegations of failures of the minister. And I think just a quick review of his judgment, which is in the Court of Appeal, page 55.
It sets out that there were, on page 9 of the judgment,
Yes,
the respondent's submission being that there were serious breaches of the minister's duties of utmost good faith to the court and full and frank disclosure.
yes, that's some of them. Failed to put forward arguments both for and against the 2020 should be discharged as an example to others because there were serious and deliberate breaches of the duty of utmost good faith. Doesn't conform with the Bermuda-India TIA.
Where does the judge deal with the complaint that the minister didn't comply with his duty of full and frank disclosure because he didn't draw the attention of the court to the expiration of the limitation period? Where does the judge deal with that?
Page 67.
67?
21 internal. Paragraph 43.
Right.
In respect of the expiry.
Well, that doesn't answer it, does it? He says, the judge says he's satisfied with the explanation that prior to filing the 2020 application, she had confirmed with the Indian authorities they still required it.
Well, my lord, in fairness to the learned judge, that's how the arguments were put to him at the time.
But look at the end of that sentence, Mr. Wilkinson. On that basis, and upon a review of the minister's minute, which I think we've agreed does not refer to the expiration of the limitation period, I am satisfied that it was appropriate for the minister to proceed with the 2020 application, even though there was a limitation period which had expired, but there were still various purposes for which there was a legitimate reason to proceed with the 2020 application. Doesn't say what they were. Doesn't deal with the argument that Mr. Keshram raises that there's no legitimate purpose once established that no tax is recoverable.
Well, I'm not sure that submission is correct, my lord, because in the context of the TIA and the request that was made under it, the expiry of the limitation period does not, according to the Indian authorities, diminish the effect of the request.
Yes, but they don't explain why.
Well, my lord, it comes down to the discretion of both the Chief Justice and Mr. Mussenden
No, it doesn't.
in terms of whether they thought there was relevance still to the request.
But in order to decide whether a document should be provided, you need to know what is the tax purpose for which the document is sought, and why the document that is sought is foreseeably relevant to the tax purpose identified. If all that you say is, I know that the limitation period has expired, but we'd like it for appellate or other purposes, you are A, not identifying the tax purpose in question, and you are B, not explaining the relevance of the documents that you seek to the purpose that you have not identified with any clarity.
Well, in breaking down the sentence, my lord, in the letter, it may please be noted, so this is the page 80,
Yeah,
Right?
yes.
it may please be noted that the information sought in this case would be useful even beyond the date during appellate stages. Now, if we just stop there, that it identifies that even if there is an appeal, it is still useful. And the
Appeal
appeal,
from what?
well, my lord, that's where we do not take on trying to explain what India wants. It appears on its face, we would submit, my lord, that it is relevant to this case.
It is asserted to be potentially relevant to an unexplained appellate stage in circumstances where the tax issue to which the request relates is in relation to a tax period that has expired, in consequence of which there can be no relevant appeal.
Well, that's, if I may say to my lord, the suggestion of an English law lord sitting in Bermuda as a justice of appeal about what the Indian tax authorities say about Indian tax.
Which goes directly to the point that if we can't, as English/Bermuda judges, understand what the purpose is, surely it's incumbent upon India to explain what the purpose is.
Well, I'm going to perhaps, and I take full blame for this, and I'm going to try it once more. If they have said in the body of the request that the purpose of the request, and I just pull up the tax purposes,
Income tax.
it's for 10, 11, and 12 will be relevant. Income tax, determination, assessment, and collection of taxes on the basis of inquiries conducted under the Indian Income Tax Act 1961. It's been found that Reliance Globalcom has been providing fiber optic capacity to Indian client Tata, collects fees. Taxpayers' contention is that the revenue from such services is not taxable in India, no business connection. Income tax department has been taxing such services. The place of control and management is Bermuda. So the income tax department has been taxing
But
such
it
services.
doesn't deal with the fact that the limitation period has expired. That surely is part of the relevant background.
Well, the income,
You have to read this document as a whole. What it is concerned with is the determination and assessment and enforcement of income tax potentially due in respect to the funds received by Reliance from Tata Communications Unit in respect of the financial year 2015 to 16. The urgency of the request being that the limitation period in relation to that tax expires in December 2018. You can't pick and choose little bits of the boxes. You have to read.
no, and I fully appreciate that, my lord. My lord's absolutely right to correct me. But when the tax authority says it is to be noted that the information sought in this case would be useful even beyond the date during appellate.
Well, that
Proceedings.
immediately begs the question, why? And you would expect the Indian government to tell us why, and Ms. Mahogany Bean to put that in her affidavit.
And during an appeal from what?
Well, we do know that they have been taxing the that section I just read. The Income Tax Department has been taxing such services. So they've been taxing them. Is it their appeal?
I don't know, you tell me.
I don't think, my lord, on its face, that it's right for anyone to speculate,
Well, I know
because on
that's
its
the problem.
face,
That's the problem. On its face, it is not apparent that the information in question is relevant for the tax purpose specified.
well, that's, my lord made very clear what his views are.
Well, I may be wrong. The fact that I express myself clearly doesn't mean I'm right.
Well,
But that is the problem that we have to grapple with.
the issue arises, of course, my lord, because it's the application before the judge at 5.2 as to whether he was satisfied the conditions of the applicable agreement in relation to the request were fulfilled. And I can already hear my Lord Bell saying, well, he wasn't told about the limitation period.
Yes, and in order for him to be satisfied, and then he's got a discretion, it comes to the moment, in order to be satisfied with the conditions of the applicable agreement are fulfilled, he needs to be satisfied that the information that he sought is foreseeably relevant to the tax purpose for which the request is made.
And foreseeably relevant, even on my friend's authorities, my lord, is so wide. He put in the authority of Blue Ridge, which is a re-emphasis of the interpretation. There are a couple of documents that I can take my lord to on that point. Let me go firstly to tab, and I hope my lord has it because it was one of the later tabs. My Lord Clerk,
Interject here, please. Just before you proceed further, Mr. Elkington, just a moment.
15.
I'm sorry, Justice Smelly had a.
Oh, sorry. Yes.
Yes, before you proceed to look at what foreseeably relevant might mean, is it fair to say then that learned judge below, Justice Mussenden, appeared to have proceeded on the basis that he was obliged to accept as face value the assertion that notwithstanding that limitation period had expired, the information would be relevant during appellate stages and for other purposes?
No, my lord, he would not have had to do that at face value. He would have formed his own view as to whether or not that met section 5.2.
On what basis is it apparent that he formed that view?
It's on the basis that I always presume judges to do things correctly, my lord.
Well, that won't do with an explanation.
Well, there's no direct express provision in the judgment.
So it would be nice to assume that it is correctly, but we don't know why.
Correct.
And indeed, we don't have the information on which you would have examined that issue because there's no explanation provided.
No, I think the best I could get, just with a quick review, my lord, and maybe subject to a further review of Mr. Mussenden's judgment, was the reference I gave the court earlier.
It's paragraph 43. Yeah.
Yes. Shall I proceed, my lord Smelly, or?
Yes, thank you.
Thank you. I was taking my lords to tab 15 of the authorities bundle in relation to the commentary on Article 26.
I have at tab 15, a commentary on Article 26.
I'm grateful, my lord, yes. And it talks about foreseeably relevant over at paragraph 1. So this is an accepted interpretation of the language used.
So this is an extract from a textbook or paper or?
No, this is, this is put out by the OECD itself.
I see.
And I think as Mr. Kasram's already referred to, in Bermuda, this has been judicially cited on several occasions. And it talks in page 398 about what paragraph 1, at paragraph 1, the main rule concerning the exchange of information is contained in the first sentence of the paragraph. The competent authorities of the contracting states shall exchange such information as is foreseeably relevant to secure the correct application of the provisions of the convention or of the domestic laws of the contracting states concerning taxes of every kind and description imposed in these states, even if in the latter case, a particular article of the convention need not be applied. The standard of foreseeable relevance is intended to provide for exchange of information in tax matters to the widest possible extent, and at the same time to clarify that contracting states are not at liberty to engage in fishing expeditions or to request information that is unlikely to be relevant to the tax affairs of a given taxpayer. And that it goes on to talk about they can agree a different
And
alternative.
wouldn't that cover a matter such as the expiration of the limitation period? Rendering the information unlikely to be relevant?
Well, it would, but in our submission, my lord, we say that the language used in the appellate proceedings saves it, and it establishes foreseeable relevance. My friend has helpfully provided a case, Blue Bridge Trust. And there we see the interpretation again of the TIAs, and this is at tab 7 of the authorities bundle.
Right.
And I would adopt what Justice Lafreniere has pronounced, starting at paragraph. Firstly, no, let me firstly bring your attention to make good what I said earlier, but though I think it is accepted. At paragraph 20 of this judgment, my lords will have seen at the very outset, this is a Canadian request relating to France. And Canada is a member of the Global Forum on Taxation. And I'm just looking here at page 751 of the judgment, paragraph 12. 2016, Canada was a party to 121 bilateral tax treaties. 751 at the top, my lord. If my lord sees the judgment is numbered at the top.
Yep.
And I'm just reading, my lord, where it just generally talks about the convention in Canada and that it's an exchange of information. This is at the bottom. Under bilateral international tax agreements constitutes a specific function of the competent authority, and that's the Canadian Revenue Authority. And we see over the page in paragraph 17, the same article that we have in Bermuda, the exchange of information, the Article 6. So if I may then take words to 18, top of the page number inside the judgment, 754. And at the bottom, paragraph 18. And Crown Forest Industries in Canada, the Supreme Court of Canada established that tax treaty interpretation differs from statutory interpretation. In interpreting a treaty, the paramount goal is to find the meaning of the words in question. This involves looking to the language used and the intention of the parties. At paragraph 43 of the decision, the Supreme Court specifies that a tax treaty must be given a liberal interpretation with a view to implementing the true intentions of the parties. And then at paragraph 20, this means the OECD's Model Tax Convention and its related commentaries carry significant weight in interpreting the convention. The provision of Article 26 of the convention must be read in the light of its primary objective, which is not to limit the scope of the exchange of information, but rather to encourage it to the maximum extent possible. So, my lords, that's at page 755 of that judgment, paragraph D. And those last words, encouraging it to the maximum extent possible. In other words, to encourage the scope of the exchange of information. So this case is in the context of France having passed legislation that retroactively taxed trusts where beneficiaries of the trust resided in France. So even though the trust may be based somewhere else, the French tax authorities took it upon themselves to say, if you're a beneficiary, even though you're only a discretionary beneficiary, you may owe a percentage of the trust value to us. And notices were served on these gentlemen in Canada who contested by way of judicial review these letters of request, these notices for production, I should say. And the part I was going to take, my lords, to that I started to go to earlier, paragraph 89 on page 767. And this is with reference to 88 about the trust claiming that the minister should have performed a new analysis for these cases on the basis of evidence submitted, etc., with detailed knowledge of all the facts relating to each of the French residents named in the requests. According to Bluebridge, had the minister performed such analysis, she would have refused to act on France's request. I agree with the minister, paragraph 89, that this interpretation of her duties is unreasonable and would have the effect of disrupting the effective and efficient operation of the provisions of the convention. Nor is it for this court, in reviewing the lawfulness of a request for assistance based on Article 26 of the convention, to perform a close analysis of the facts and the law of the requiring state, or to substitute its opinion for that of the minister. This was the conclusion reached by the Court of Justice of the European Union in Berlioz Investment Fund, SA. And then inside that, the internal paragraphing of that case, the requested authority, that is Bermuda, must in principle trust the requesting authority and assume that the request for information it has been sent both complies with the domestic law of the requesting authority and is necessary for the purposes of its investigation. The requested authority does not generally have extensive knowledge of the factual and legal framework prevailing in the requesting state, and it cannot be expected to have such knowledge. In any event, the requested authority cannot substitute its own assessment of the possible usefulness of the information sought for that of the requesting authority. And then it goes on, it must be held that the limits that apply in respect of the requested authority's review are equally applicable to reviews carried out by the courts. Consequently, the courts must merely verify that the information order is based on a sufficiently reasoned request by the requesting authority concerning information that is not manifestly devoid of any foreseeable relevance, having regard on the one hand to the taxpayer concerned and to any third party who's being asked to provide the information, and on the other hand to the tax purpose being pursued. And as my lords will be aware, sometimes, often enough, production orders are served on third parties, not always the taxpayer. In this case, it is the taxpayer.
Well, what was the nature of the process in the Canadian case? Did the judge make the order?
No, my lord.
No.
It was the old system that we used to have in Bermuda of the request going from the
Where the only,
the minister issued a notice.
and if the taxpayer took objection, then it had to be done by way of judicial review.
As Mr. Kestrom, quite right, my lord, as Mr. Kestrom said earlier, when the statute first came out, it actually had an express provision that judicial review was available. And the history of the cases in Bermuda shows that that provision was deleted by amendment. And then we had applications to the court that it was appropriate that the minister provide the underlying request so that it could be tested against his order. And it was, and I think the case may even be in here, was post the Bungie case. Yes, Mr. Kestrom was quite right. In tab 16, we have the Minister of Finance and Bungie Limited. And in that case, that was one of the last cases where the minister had issued the production order. And what's interesting, my lords, is that was the 18th of November, 2013, the decision in that case where the Court of Appeal, this court, upheld the judge's decision below that the party served with the order could see the underlying request. And I think it was somewhere around the 13th of December, 2013, that the law was amended to interpose the court.
Yes, but if the position is that the court is interposed and the obligation of the court is, or the court, in order to make the order, must be satisfied with the conditions of the applicable agreements relating to the request are fulfilled. That may be thought to be a different scheme of things, so that literally the court is required to be satisfied of that. And observations which rely upon paragraph 90 of Blue Bridge, that the requested authority must in principle trust the requesting authority and assume that the request complies with domestic law and is necessary for purposes of its investigation. That might be an assumption that the requested authority is required to make in where the arrangements are, as in the Canadian case, but it can't be right that the Supreme Court is obliged to make any such assumption. Right? The Supreme Court has got to be satisfied.
Yes, it just, the section 5.2 says there must be some relevance that these conditions are complied with.
Yes, but I mean, that requires the court to be satisfied that there is such relevance.
Yes.
The fact that the requesting authority says it's relevant is not something that is conclusive.
Absolutely not, my lord. My lord's absolutely right. And I don't think we've ever said that in the terms that my friend was submitting had been put forward by the minister. Well, the minister's
position. That's fine, but the passage you appear to be quoting appears to indicate that the requested authority must assume that the documentation is necessary for the purposes of its investigation.
Well, I think where there's one thing where there's no connection, there's another where there's an interpretation to be made. I think that's how I submitted to my Lord President. If the court is able in its discretion to discern that there is foreseeable relevance, for example, then why shouldn't the court be allowed to exercise that discretion?
But the
Unless
problem
it's
is that
manifestly-
requires the court to make sense of the document at page 80 when Mahogany Bean hasn't given any assistance.
Well,
And this may be a good moment, Mr. Elkinson, just to draw your attention to the words of Mr. Justice Hellman, which you will have seen, no doubt, many times before, because one can't help but notice that nearly all of the cases involve you are on the one side and Mr. Kesram on the other, sometimes acting for the minister and sometimes acting for the taxpayer. But at the end of tab 6, in the case of AAA, page 22, what Justice Hellman said was, this is the second case in a matter of months. And I just paused there to say, one can tell that one of the cases would be the case of AP, which Mr. Justice Hellman decided and which went on appeal to this court, and which dealt with the question of full and frank disclosure. So Mr. Justice Hellman says this is the second case in which the court has varied or discharged production orders due to the applicant's breach of the obligation to make full and frank disclosure. The requesting state is expected to assist the minister by supplying him with the information necessary to comply with his obligation in this regard. And I'm sure that those words were matters which you would have drawn to your client's attention since you acted for the minister in that case. So Justice Hellman's point was that so far as this jurisdiction is concerned, the duty to make full and frank disclosure is there, and it's up to the requesting state to assist the minister by supplying him with the necessary information. And well, we've been over whether the document at page 80 is satisfactory in that regard.
yes, in fairness to the minister in that case, he hadn't been informed of something by the Swedish authorities. And that's seen at paragraph 42 of that same judgment.
Well, that's not the minister's fault, but the bottom line of all this is that if the request is going to be acted upon, it's necessary that the minister is supplied with the correct information, adequate information. If he isn't provided with it, the likelihood is that the request will be denied, and therefore it's rather important that before he makes the request, he asks for the relevant information.
That is noted, my lord, but equally in this case, we had, and it ties in with the questions that were asked earlier of Mr. Kesram about what is the role of the court vis-a-vis Mr. Justice Mussenden. What's his function? Is he a review court? Is he hearing de novo? And in the circumstances, we would say that here, another judge of the Supreme Court has everything argued in front of him, insofar as Mr. Kesram has argued, and I'm not quite sure how well it was put at the time, about the letter not giving sufficient explanation in respect to the statute of limitations. But the fact is that he concurred with the Chief Justice that this was a case where a protection order should issue.
Well, I know you did, otherwise we wouldn't be here. But I would have thought the answer to the first part of the question is that on the ex parte application, the court must be satisfied that the information is it is foreseeably relevant to the tax purpose identified, and that upon a review, the reviewing court should reconsider in the light of all the material that it then has, whether or not the information is foreseeably relevant to the tax purpose identified, so that it performs the same exercise as the ex parte judge, but with such material which may be more than the ex parte judge had, as it has before it. And the problem with Mr. Justice Mussingham's case is that when one asks oneself, well, why was he satisfied that the information sought was relevant or suitably relevant to the tax purpose identified, it's not possible to discern from the very short paragraph a previous judgment which deals with this at all why he was.
Well, as Mr. Hellman said in that AA case, its relevance is either readily apparent from the background material provided in the request, even if the request does not spell out the link between the requested information and the investigation in express terms. I mean, on a general basis, I would still try to urge my lords to accept the proposition that the language used in the cover letter is still sufficient to tie in what is set out in the request to be relevant, such that the conditions for the Supreme Court to make an order are satisfied.
Right. Yes.
So, my lords, to be clear, the position of the minister is that there was a clear, there was no breach of an obligation to disclose material facts. It may well be, and I fully accept the criticism levied by the Lord Bell, and I may well be joined by others, that Ms. Bean should have set out in her affidavit about the limitation period. But my friend's submissions in this matter concerning the minister's defaults are, shall we say, extreme. At one stage, certainly below, there was some suggestion of a tactical advantage by the minister by failing to make disclosure. The issue that was focused on by my friend below and in his skeleton still was that the reference to the affidavit of Mr. Riley was inappropriate. That was a major focus below. And if I may take my friend's submissions, which he has started off at paragraph 14, page 6. And this starts with the reference to the failing to identify a legitimate tax purpose. And we say, my lord, the legitimate tax purpose was identified. I cannot move away from those submissions.
Which was the legitimate tax purpose identified?
That the legitimate tax purpose, it was to determine, assess, collect taxes in respect of which there had been taxing of Reliance Globalcom, and that there may be, that there is an issue.
Interrupting you, I'm sorry.
Go ahead, Mr. Bell.
Would that not presuppose that the tax in question was collectible, and that would not be the case if the limitation period had expired?
Well, again, one sees that the tax purpose, if I may, my lord, answer in a long way, the tax purpose is in box 11, which is 82. So it's the determination, assessment, and collection of taxes. We read that they've been doing business in India, according to the Indian Tax Authority, that they have been taxing them, that there is a limitation period engaged, which is why they want an urgent reply.
Well, they've
And
only
that
got
in their
4 days
covering
to go at
letter-
that point, don't they?
So again,
We've got 4 days, well.
Yeah.
Yeah.
and in respect of that limitation period, the information in the case is still of use, would be useful. So I would use the words of
It doesn't
use.
say why, that's the problem.
Well, it does. It does, my lord, and with full respect. During appellate, I mean, it's still the case,
Sorry,
and
which
there's an
document are
appellate
we-
procedure.
Which document are we looking at now?
Sorry, I've gone through all three, my lord. So I started at page 82 of the record.
The information requested.
Yeah, and then I went back to the covering letter at page 8.
Right.
So I can't move away. Unfortunately, perhaps I should take the hint, but the letter still says the information sought in this case would be useful
Right. And
during the appellate procedure.
Yes,
So
but
there's still a tax purpose.
it doesn't tell us what the appellate procedure
Well,
is.
What would my lord have expected of
An
full
explanation
chapter
as
and
to what the
verse?
appellate procedure was.
Well, this goes, my lord, to this issue of giving this a wide ambit, foreseeably relevant. It at least
Means
explains.
something a wide ambit doesn't mean that something which is entirely dealt with should be assumed to mean something specific.
Well, we know, I appreciate my lord saying that, but you know, my lord may have done this differently if my lord was sitting in the Supreme Court, but I'm minded of this, that they had more, and I know I can't teach my grandmother to suck eggs. My lord knows this better than I do. These were discretionary views of the judges that this encompassed. This was caught up in section 5.2, that it was relevant.
Wait a moment, that's not right. There are two different questions. Firstly, whether or not 5.2 is satisfied. If it isn't, no question of a discretion arises. If it is satisfied, there is still a discretion. But it is wrong to say the question as to whether 5.2 applied was discretionary. It wasn't. It either did or it didn't.
My lord is right, and of course, my lord is always right. No, but the discretion I'm referring to, my lord, in 5.2 is the judge may issue a protection order. That was the discretion.
Well, that brings me to another thing, because if the position was that if a 5.2 was satisfied, the position was on any view only just established because the whole thing was unclear. He might, I suppose, as an exercise of discretion, said, "I'm not don't think it right to produce the or make the protection order now, because we should go back to India for them to explain what they really mean."
Yes, that's why he doesn't have to. He doesn't have to issue the protection order. And this comes back again to Mr. Mussenden. Mr. Justice Mussenden heard the whole thing with all of these arguments made, and still found that
Well, I know he
5.2
did
was
that. I
satisfied.
know he did that without any sufficient explanation of his reasoning.
Well,
Judgment goes on for a long period of time. The relevant passage is one paragraph.
Well-
It's 3 sentences.
in fairness to the judge, my lords, if one looks at the skeleton argument that was before him, there were many, many points, and these are tab 15 of that, at page 137, I'm sorry.
Yes.
I mean, if one looks at the outline submissions, we get the first few pages of what was before the judge. Page 139, the court was seriously misled.
Well, I know the judge was no doubt distracted because, as so often happens in these cases, everybody files filial also in relation to the submissions rather than concentrating on the 3 critical points.
Well,
But that's something that judges simply have to live with.
And it often happens that there are many points taken below, and when one moves up a rung,
They fade into this.
Well, and also in fairness to his lordship below, the focus on the limitation period was a lot lighter,
Right,
putting it mildly, than it is at this stage.
yes, well, that's not unknown.
And so when my lords have asked, and my Lord Smelly asks, why is the judge not dealt with it in any great detail?
But the judge did purport to deal with it.
Yes,
Yes,
The
but
problem was that his reason didn't actually explain anything.
well, as I say, my lords, it was if when one reads the skeleton argument, one will see it's not a big focus, if it's even a focus at all.
Yes,
And-
but the problem is that the judge's words don't explain how he in fact viewed the matter of material disclosure.
Well, I would submit to my Lord Bell that perhaps the judge took the same view that I'm trying to put forward now, which is that and I know that it's not a practice that's frowned upon where there's voluminous materials, but by the affidavit of Miss Bean referencing the very document that the judge has to look at, which is the request. And I know my friend tries to separate the request from the cover letter, but they go hand in hand, there's no question. So the judge would have been aware that A, there was an expiry of a limitation period, and B, that the request says that it still has utility. I appreciate that my lords don't necessarily agree with me on that point. But we submit, my lord, that the request had utility in whatever the appellate proceedings were, that the learned Mr. Justice Mussenden didn't see any non-disclosure or breach of full and frank on the part of the minister, because those documents were there.
Well, but at the end of paragraph 43 of his judgment, he says there were still various purposes for which there was a legitimate reason to proceed with the 2020 application.
Yes.
He doesn't say what they were, and he doesn't say where they can be found. And for my
Lord,
part, I
that-
don't understand what they are.
If I could say, my lord, clearly from just the fact that my lord identifies that, he clearly had it in mind that there were legitimate purposes,
Which up to
and the only ones he could have found would have been in the cover letter.
But even that part of the cover letter doesn't make sense.
Well, with respect, my lord, it does say in this case there are appellate proceedings, and we will still be using this information. And Mr. Smelly has his hand up.
That's right. Justice Smith.
Yes, thank you. I think it's also a matter of concern that it was stressed to the judge below that the court ought to take a very light touch approach to these matters. And whether that might have resulted in the sort of examination shown in paragraph 43 of the judgment. If you look at paragraph 21, for instance, of your submissions, at page 165 of the bundle, you seem to be
21 of whose submissions, my lord?
of your submissions below.
Oh, if my lord, is my lord making reference to the expression administrative process?
Yes.
Yes.
You are encouraging the court to approach the matter as if it had a very light touch administrative review of the request.
No, if I may explain, my lord, the reference to that, in fact, I think in my later submissions that my lord has in this matter, explain why that expression appears. It wasn't to say that the court is acting as an administrative arm and just ticks boxes and just issues orders. What I was explaining, my lord, was the history of the matter in the context of what I was explaining to President earlier. We had the issue of the minister being the competent authority, And in 2013, it changed to the court. And over the years, what's happened is legislative amendments have happened, usually relatively quickly, to make it harder and harder for parties to get access to either a review or primarily the underlying documents in the matter, and to try and make the processing of requests from requesting countries quicker. What I was referring to is the court becoming part of the process, of the administrative process of the minister, of the competent authority, not making a reference that it should be a light touch or that the court is just an administrative body. I would urge my lord to fully accept that the minister does know that there is a duty of good faith, full disclosure, and that language, as I say, my lord, becoming part of the administrative process of issuing production orders was in respect of the history. The amendments, if I may, my lord, if you go to the beginning of the paragraph, which I'm sure my lord has read, the amendments to the legislation over the years has nothing to do with protecting the rights of the Bermuda public. The reason that that's there is that my friend, Mr. Kesseram, was saying that the only reason these amendments were made were to protect the public. If you read his earlier submissions, that these were all about human rights and making sure individuals' rights were protected. And I was saying to the judge below, and you'll see it in my submissions, that actually, on the contrary, it was all about Bermuda fulfilling its treaty obligations in the most efficient manner possible. And all these changes were for that purpose. So taken out of context without that background, I can see why my lord would be concerned. When the minister is saying, oh, it's nothing to do with protecting the rights of the Bermuda public. That was just in response to Mr. Kesseram's very strong submissions below. And the judge deals with them in his judgment, that these were all about protecting individual rights. And then I say, on the contrary, it was an attempt by Parliament to make the obtaining of the information as required under Bermuda's treaty obligations easier, to restrict the right of any party served with a production order to delay the process, not least in seeking to have sight of the documentation issued by the requesting country to the Bermuda Treaty Unit, which processed the request. It was this that led to the court becoming part of the administration process of issuing production orders. So that's why I say, my lord, that background hopefully will clarify that that was not seeking to demean the role of the court in any way or suggest that it was just there to tick boxes. So this expression light touch, it's not there, it's not expected, my lord. In fairness to Miss Bean, she put in those papers, as we'll see, to be either heard or to be dealt with on the papers. The Chief Justice, in the initial application, had the option of asking for a hearing, but he chose to say, I'm going to deal with this on the papers. It was his decision to do so.
And may the answer for that not be that, with no disrespect to the Chief Justice, he hadn't appreciated the relevance of the limitation period expiration point.
Or it could be, my lord, that he fully appreciated it and just felt it was appropriate to issue the order. I mean, it was his view we would submit, and we think it must be right, because my friend seems to suggest.
Well, he made his order, so it must follow from that.
Yes, yes. We say, my lord, he would have seen the request very clearly as one document, because Ms. Bean actually refers to it as that in her exhibit. She doesn't distinguish between the letter and the request itself.
I have your point there.
So on that basis, we say there is a nexus, that 5.2 was satisfied such that the Chief Justice exercised his discretion to issue the production order. And then under 5.6, my friend comes and seeks his review. And in that context, he has another chance to explain to Mr. Justice Mussenden what it is that's egregious. As I say, we look at his submissions. This whole point about the limitation period, I'm not even sure If the only time it appears as I look through is at paragraph 45 of page 152 of the correct record.
These are the submissions below.
Yes. Respondent maintains that for reasons set out in ground 5, the application for review that the information sought is on its face so wide-ranging, oppressive, no geographical limitation to India, or rational connection to the specific tax issues said to be in dispute, that it is clear that the request is a classic fishing expedition or being used for collateral or other purposes, particularly as the covering letter alludes to unspecified other proceedings or appellate proceedings discussed below. And then at 47, the covering letter states, and he says what it states, nothing further is contained in paragraph 48 in the documents in support of the application to identify what appeal proceedings are referred to, what issues the request was aiming at resolving. This too was a deficiency in the request, which rendered the request non-compliant. So those last few paragraphs at the end of the submissions touch on the limitation issue.
Well, he'd also raised it at 30A when he says the same question was present in February 2019, not 20, namely, was the request still relevant after December 2018 with respect to all of the matters which the information was sought, as the request specifically identifies the statute of limitations date of 31/12/18.
Okay.
Can you just help me whilst we're at that forward? At the end of your submission, your written submission, paragraph 8, you say the minister submits the court should reject the appeal in this matter and further seeks that the court by its ruling align the process of the application for production order in Bermuda with the process in respect to applications made ex parte pursuant to mutual legal assistance obligations.
Yes.
Now, I had thought that to be an invitation for us to say that the doctrine of the obligation of disclosure and good faith and the like did not apply.
That would have been an invitation if I had been correct in my interpretation of UNA Energy number 1. But number 2.
But wait a minute. So you don't do that was what you invited us to do, but that's not what you invited us to do now.
Correct. I'm grateful.
Right. Just one. Yeah.
And I want to be clear, my lord, that that was an alternate to the primary position, which is that all the duties were complied with.
Yes,
And
that's I follow. That's I follow. But you
Yes.
no longer suggest
No.
that there isn't a duty and we should so say.
No, I am not suggesting that and anymore.
No, thank you.
And in respect of, well, I won't dwell on that issue. There's no benefit to me in doing so. Because the bigger point is, it wasn't that I was saying that there shouldn't be any duties whatsoever. Because even in respect of letters of request and the issue from country to country, there's a duty that it's a fair presentation at the very least. So the issue is, do you apply a rigorous high duty that applies, for example, in commercial litigation cases where there's an ex parte application required, or even in, as we saw, the search warrant issues?
Yes, well, the distinction between a fair presentation and the duty which complies with the presentation which complies with the duties of disclosure is somewhat difficult to work out. Fortunately, we do not need to do so.
So, in other words, the submissions that were provided to you, nothing has changed in regard to that, except for obviously, as my Lord President has quite rightly reminded me, that we should not be in any longer proceeding on the basis of UNA Energy and any variation of the duties. But I do want to emphasize, and it comes to mind because of Mr. Justice of Appeal Smelly's question about the light touch. That was never the minister's position. And it was always below that he had complied with his obligations. And the matter that appears. The issue, my lord, is whether in these matters there is a clear. I think that the two points that remain, my lord, is was Section 5.2 complied with, and was there, if it was complied with, was there a failure of the duties of candor, good faith, disclosure? We say 5.2 was complied with. And interestingly, of course, it ties right into the very issue of candor and disclosure, because appellant's position in this appeal is that we should have brought to the attention of the judge in the affidavit of Miss Bean the question of the statute of limitations. We say that on its face, that the request made clear that the information was still useful, that it didn't need to be drawn to the judge's specific attention. It would have been useful, but even before Mr. Justice Mussenden on appeal, he didn't see fit to set aside or vary the order because of that. This whole question of foreseeable relevance, I just wanted to conclude on that point. I think got slightly detoured, but it was in the case of tab 10 of Assessor of Income Tax and Homecroft. And it's very short. It's just on this very point. At page 13 of 18 within that report, and the page number being on the bottom. And the Lords will see at paragraph 18. And this is where it's extracted from the commentary. Both counsels submitted that you cannot improve on the definition of foreseeably relevant contained in this commentary. Namely, that there is a reasonable possibility that the requested information will be relevant. We would,
which page would it be?
sorry, 13 of 18 at the very
13, I see, yes. Yeah.
grateful, my lord. Paragraph 18
Yes, thank you.
within the body. Both counsels submitted you cannot improve on the definition contained in this commentary. Namely, there's a reasonable possibility that the requested information will be relevant. Whether the information once provided actually proves to be relevant is immaterial. It is also a useful definition of what is meant by fishing expeditions, namely speculative requests that have no apparent nexus to an open inquiry or investigation. We would submit, my lords, that the corollary of that is that goes to whether the language appellate proceedings, that the information in this case will be useful for the appellate proceedings, is such that it shows that it wasn't speculative, that there is a nexus, there is a tax investigation taking place in India, and therefore there is a reasonable possibility that the requested information will be relevant.
Does rather beg the question as to why new information should be relevant for the purpose of appellate proceedings.
Well, this has arisen in various cases, Lords, where sometimes a respondent to a production order says, I've given them documents back in my home country. And the question is, well, are they relevant that they're asking for these documents more or less or the same? And the answer has arisen that it can be useful because it can either verify or show that what's previously been provided has been inaccurate. So there are many reasons why the tax authority might want to ask for documents from a different source. My lords, unless you have questions for me, I've certainly nothing further to submit.
Justice Smelly, do you have any questions?
No, thank you, Mr. Wilkinson.
You're moot. I think that was an answer.
I think it looked like a negative.
I think it was a negative.
No further questions. Thank you.
Mr. Kessel, what would you like to do? Would you like us to break now? Okay. Well, let's take your 5 minutes.
Would Mr. Kesseram please unmute his microphone?
Hang on, Justice Smelly was speaking then. Suddenly very, very faint, Justice Smelly.
Yes, Mr. Kesseram's microphone needs to be unmuted, please.
I can hear something, but it's so faint I can't make it out.
How is that? Can you hear me any better?
No, can't hear you.
Mr. Kesseram's microphone.
Still can't hear.
Still can't hear.
Can you hear me now?
No.
Gosh, I wonder whether I turned it more. Can you just try once more, Justice Smith? Can you speak again?
Yes, can you hear me now?
Yes.
Can. I'm sorry, I pressed the wrong button.
Sir Christopher is wholly responsible.
I'm asking Mr. Kesseram to please unmute his microphone.
Right. Right. Have you done that?
Thank you. Yes.
Yes, I can hear. Thank you.
Thank you. Now, what are the two cases? You want?
Yes, the first case is Blue Bridge, which is at tab 7 of the authorities, joint authorities budget. And I'd just like to bring you to the paragraph of that judgment referred to by my friend on page 767.
Yes.
And it starts at paragraph 86. And the issue here is
Paragraph which?
86 of the judgment. Sorry, 89 of the judgment. 89 and 90. And the issue here is whether there needs to be shown to the court whether there is a connection between the tax purpose and the information that is being sought. Our proposition is that, yes, it is incumbent on the Minister of Finance, in our case, to demonstrate to the judge, the ex parte judge, that there is a relevant connection, or for the judge to be satisfied in some way that there is a connection, a nexus between the information sought and the tax purpose of the requesting state. Now, in this judgment at paragraph 89, the judge, and in particular 90, the judge refers to the Berlioz case and quotes from the judgment in that case. And what I'm suggesting is that this judgment is actually supportive of the proposition that, yes, there must be shown to be some connection. It's just put in a different way. The way it's put in paragraph 86 of the judgment in Berlioz, and this is at the very bottom of the page 767. Consequently, the courts must merely verify that the information order is based on a sufficiently reasoned request by the requesting authority concerning information that is not manifestly devoid of any foreseeable relevance, having regard on the one hand, etc., to the taxpayer, and to any third party who's being asked to provide information, and on the other hand, to the tax purposes. It's just being put in a different way. There has to be shown some connection, or as it's put here, it must be not be manifest, the request must not be manifestly devoid of any connection. The parts that my friend was relying upon were passages in the judgment which relate to the requesting state's laws under which the tax investigation or tax liability is said to arise. And of course, that's a matter for the requesting state. It's not for the Bermuda court to question whether there was any liability to pay tax in the requesting state. Similarly, with respect to facts which support the imposition of a liability, those are matters that the requested state must take at face value in the request, because those are not matters it can investigate or should investigate. It should assume that the request is made on the basis of true facts under the law as it's believed to be by the requesting state. But when it comes to the connecting the information requested and the tax purpose that is being served, the Bermuda court must be satisfied that there is a relevant connection, albeit one that is not as rigorous as would exist in a discovery application under the civil rules, Supreme Court rules. And as it's put there, must not be manifestly devoid of any foreseeable relevance. And the second case I would simply draw my Lord's attention to is the case of Minister of Finance versus EFH&O. It's at tab 5 of the bundle of authorities. And I'd just like to draw my Lord's attention to what was said in a practice note in that case at paragraph 70 of the decision. It was Mr. Justice Hellman again. He and I'm not going to read the whole practice note. I draw it to my Lord's attention. But
what was the paragraph number?
Paragraph 70. I'd invite my Lords to read the whole of the practice note there. But in paragraph 70 of the decision, he said the request for a production order should explain how the requested information relates to the purpose for which it is sought. Does my Lord have it? It's on tab 5.
Yeah, I've got the case. Repeat the paragraph number, 70.
70.
Thank you.
The request for a production order should explain how the requested information relates to the purpose for which it is sought. It is not for the court to speculate. And then he says, if the request does not do so, the court is likely to adjourn the application pending receipt of an adequate explanation. This is not because the court wishes to be obstructive, but because the court takes its duty under under the 2005 Act series. Well, that's precisely the matter, the circumstances we're facing in this case.
Right.
Thank you.
Thank you very much. We're most grateful for it.
Justice Smelly.
Yes, does that then suggest, Mr. Kestram, that you are inviting us to adjourn the matter for an explanation?
No. I'm suggesting that the ex parte judge had the matters that ought to have been disclosed or brought to his attention, had they been brought to his attention, an option open to him would have been to say, I'm going to adjourn this application, go back to India, answer these questions for me.
You're inviting us to set aside the order, full stop.
here I'm asking for the production order to be discharged with costs.
So one possibility is that we could say it should be stayed. The question as to whether or not it should be enforced in the future should be adjourned until the authorities have produced more information.
That is an option.
Right. Thank you.
Thank you.
Right, well, as I was saying, I'm very grateful to the parties for their helpful submissions. We shall endeavour to give judgment as soon as possible and in slightly less time than the Canadian court did in the case of interference with protection. Thank you very much.
All right. Shall we have a breakout room, Mr. Coelho? Hello, gentlemen.
Thank you.